In this opening case, the courtroom takes on a quiet but tense rhythm. A mother faces charges for endangering a child, yet insists her plea is voluntary. What sounds procedural quickly turns personal as every yes ma'am echoes the weight of a life under judgment and the system's watchful eye.
Good morning. Are you Donnell Coleman?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will.
Ms. Coleman, in cause number 25 DCCR 0222, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from January 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Coleman is not competent?
No, Your Honor.
Ms. Coleman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll go forward at that time. Before you leave the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Now the tension rises. A defendant tangled in a bizarre patch testing mess faces a frustrated judge who's had enough. 2 clinics, 2 drug patches, and 1 mystery of missing accountability. This isn't just confusion, it's chaos. And the courtroom's patience is about to snap under the weight of excuses.
Okay, so Mr. Mack, after trying to figure out what was going on, and my clerk and I talking to everyone and figuring out what's going on, here's what I think we figured out. We know what you're doing. So you're getting a patch from Johnny's or from Al Reed on the same day and going in with a clean one to get tested. Why are you getting patches at 2 places?
To explain to her what we talked about it in private.
I got 2 patches because I thought Al Reed patch was for Al Reed and Johnny's was for you.
He's on bond with Al Reed.
Yeah.
So did Al Reed tell you you had to have a patch?
Yes, ma'am. They gave me a patch before I was even released.
So you're not showing up anywhere with 2 patches on though. So if you have 2 patches, if you're getting 2 patches, you should have 2 patches on, right? How many patches do you have right now?
1.
Okay, so whose do you have on?
Al Reed.
So what about Johnny's?
I stopped getting Johnny's because Al Reed told me I didn't have to get them anymore.
He seemed to indicate that the quality of the patch from Johnny's is different than the quality of the patch from Al Reed's, and the difficulties he was experiencing with the patch from Johnny's was because it was an inferior quality patch and came off.
So when did you get that patch? Do we know? Let me see.
I get it changed on the 7th, so 24th, 25th.
So you got a patch put on the 25th from Johnny's also.
No, I paid them for an old patch on the 25th.
They specifically put a date down that says, these are the dates that he has come into our office and have patches put on. And the 25th of September is one of those dates for Johnny's.
Okay.
Did they put one on or not? I understand it says that, Your Honor. I don't know that they actually did that. That's my point.
Well, they've got receipts, they've sent receipts, we've got serial numbers, we've got all of that information now.
Without them available for cross-examination, I'm not conceding, I don't know if they did or not, is my point, whether they actually put one on.
I'll take a drug test. I don't do any drugs, man.
Well, I guess I don't understand, Mr. Mack. You've tested negative, I get in court, but I feel like there is something going on that doesn't make sense. And I feel like you're playing games.
Your Honor, in all due respect, it may not be him, it may be Johnny's. That's my point. I mean, the assumption seems to be it's the defendant's fault. And without having them available, I'm not conceding that there may be something, the problem may reside with Johnny's and not the defendant. I'm not making an allegation of that, but that needs to be ruled out. Because he doesn't seem to be having problems with Al Reed doing the drug test.
Well, there haven't been issues with Johnny's other than some untestable patches that came in untestable.
That's my point. The quality of the patch itself from Johnny's is probably.
I don't understand why he got 2 patches on the same day from 2 different places.
I don't know that Johnny's actually put a patch on. He paid them on the 25th. He went in and made a, they're telling him he owes them money, so he's going in.
Right, you're all caught up. They've already said he's all caught up. But they specifically said they put a patch on and they're willing to. And they went back and checked serial numbers and sent us this information, so.
I guess I don't understand why Al Reed's not having the same or similar problems with him.
Because he just started with Al Reed and he's doing both and there's something going on. And I'm tired, I'm tired, I mean,
Okay.
I'm just tired of dealing with it.
I am too, Your Honor. It seems like I'm spending more time with this case with the drug patch as opposed to the case itself.
I'm spending more time with the drug pat. Ms. Werner spent more time with this, and the only way here's where I am, is the only way I know to make sure that there's not games being played is to put him in jail because I feel like he's playing games. But, I mean, you've got a patch on, I don't understand.
You could just try the case, Your Honor. It would be the solution if you could get it tried.
Well, it's not put it on the trial docket. It is?
I think it was.
Well, I mean, we'll get it tried on the trial day.
It's Mr. Coleman's case. I believe it was set for trial a week or 2 ago, Your Honor.
Wasn't reached.
Yes, and it didn't get reached.
Okay, yeah.
I think it was numbered.
Oh, okay, gotcha. Here's what I want. I want a hair follicle test done at Mr. Mack's expense
Where at?
today at, I think Beaumont Occupational still does that.
Oh, okay.
I'm pretty sure. Can you double check?
I'll see. I'm pretty sure Quest probably doesn't.
It really doesn't matter to me other than I don't want it done through a bondsman. I don't want it done through Johnny's. I want it done through either Quest or Beaumont Occupational or one of those places. I want it done today.
Yes, ma'am.
I want get proof that you've done that, and then I think it takes a few days to get those results, and I want those results immediately. And, yes.
You understand what you need to do?
You don't understand, but
Okay.
I just don't know how to funds. Because I just recently had a baby and
You're gonna get a hair follicle test. Figure it
Sell
out.
some plasma.
Figure it out. All right? You have 24 hours to get it done.
All right.
Okay.
In our final case, redemption collides head-on with repetition. A man pleading for one more chance after failing probation again, this time with his life on the line. The courtroom listens, but the judge has heard this song before. And today, mercy may finally run out.
Good morning. You're Antoine Dill?
Yes, I'm
And Mr. Dill, you were previously in court and entered pleas of true to counts 1, 2, 3, 4, 5, and 6 in a motion to revoke your unadjudicated probation. On probation for the second-degree felony offense of burglary of a habitation, placed on probation. I think the dates in this updated report are, must be wrong. It says on May 8th, 2025, he met with the high needs officer for the initial visit. Should that be May 2024?
Yes.
Okay, All right, just want to make sure. So placed on probation back in April of 2024 for that offense. The allegations, failure to report, failure to work, testing positive, that didn't do the theft prevention class, behind in fees, and behind in restitution. There was no agreement, is that correct?
That's correct, yes.
Mr., and I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
You have, Judge.
Any additions or corrections to that report?
Nothing from the defense, Judge.
Not from the state, other than Ms. Court has any addition.
Okay.
I would like to hear from.
Thank you, ma'am. Go ahead, Mr. Lewis.
Judge, this situation, from talking with my client as well as members of his family, is definitely one that this substance abuse issue is something that he definitely needs to address. He's willing to, he understands that that's, definitely been in his way as far as definitely trying to complete this probation successfully. I would also like to add to that after speaking with him and with some of his family members that I don't believe he was on any type of mental health or any type of conditions dealing with his probation.
He was
I know it's
high needs.
Because from talking with him, there's definitely some things he has gone through in his past that I think affect him and are triggers for him. And I believe that, if he's able to get that type of help, to help with that, I think that would definitely help with the substance abuse issue. I believe there are vehicles available through community supervision that can address that. He's more than willing to accept that help. At this point, understands he needs it. I know it looks like the recommendation in the updated PSI from probation is for ISF. It's something that they would recommend. He's more than willing to comply with that and try to work with that as much as possible. If there is anything that's available that has some type of aftercare or anything, he's more than willing to do that as well. Especially, like I was saying, as far as, any treatment he can get as far as, that would definitely help with some of the traumatic things he's gone through in his past. I think that would definitely help with the substance abuse issue going forward for him, Judge.
Okay, and the recommendation isn't necessarily ISF, it's if I were to continue,
Right.
but the recommendation sounds like they've exhausted all efforts that, anyway, Ms. Smolfino?
Judge, I certainly respect all the efforts that Ms. Court has put into this defendant, and I don't ever like to overstep what the recommendation of the probation department is with respect to trying to help a probationer, but my read of it is that it's probably time for revocation, but I certainly would defer to what you all.
Well, it sounds like that's the recommendation of probation as well, really. Is that correct, ma'am?
Yes, ma'am.
Yeah. I mean, sure, go ahead.
Please speak. I have made a lot of mistakes in my life. I really have. But I beg you, Your Honor, please give me another chance. And
But you begged me when you were here before.
Yes, ma'am. And I got out, and the second day I was back on the streets. I did not have a plan for my life outside of just getting free. I met with the ASAP team, and they really gave me a lot of inspiration, a lot of hope so that I can change my life. Granted, Ms. Court has done an amazing job as my supervisor, and I apologize to her profusely, but I am not someone who wants to waste away in a jail cell.
Well,
I am someone
so
who wants to.
Here's the thing, Mr. Deal. When I looked back at your original pre-sentence report,
Yes, ma'am.
there wasn't an agreement in that case. It was a cap. And the reason for that cap is because you already have felony criminal history.
Yes, ma'am.
You've already had 2 felony probations that were both revoked.
Yes.
And then I gave you probation again because you stood there and did just what you're doing right now. You saying the words,
Please.
you need to stop because it's not going to get any better.
Yes, ma'am.
Okay?
Yes, ma'am.
By what you can say. I appreciate that you probably would like to do what you're saying,
Yes, ma'am.
but you've been given every opportunity. Probation's worked with you. Again, those felony probation revocations, one was in 19, one was in 2021. It's not like they were a long time ago. You've been given every opportunity on probations now 3 times. 3 times. And I mean, she worked with, when I'm reading through this pre-sentence report, Ms. Core tried to contact you, she tried to
I didn't
reschedule.
have a phone. I was
She-
just texting her. I was homeless. I have been homeless a lot of my life.
But that's what probation's for, is to help you. You have to go to probation. You can't keep using those things as an excuse.
Yes, ma'am.
All right, so I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily.
Yes, ma'am.
Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a habitation. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign that with Mr. Lewis. It shows that this was not an agreement, so you do have some limited rights to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. I understand this isn't what you want. Take advantage of it, and when you get out, take advantage of opportunities in the community, because there are some that can help you.
Thank you.
All right? You can
And
go
I
back
wanna
with
say
the,
one last thing to you, Judge. I will change my life.
I hope so,
I
for
will.
you.
For me.
Yeah, I hope so. I really
Yes, ma'am.
truly do.
Yes,
All right, it's not.
Case 1 reminds us that even quiet hearings can carry crushing stakes. Behind Miss Coleman's calm yes ma'am lies a story of responsibility and how the justice system balances mercy with structure. The judge's tone is measured but unshakable. Follow the rules or lose the chance at redemption. Probation in her courtroom is not a free pass, it's a final opportunity to prove reliability under pressure. Case 2 explodes in procedural chaos. What should have been a simple drug testing routine turns into a web of confusion, miscommunication, and apparent manipulation. The judge's exhaustion is palpable. She's spent more time sorting out patch logistics than addressing the underlying criminal behavior. It's a sharp critique of how technicalities and evasions can derail justice. Her solution, a hair follicle test, isn't just practical, it's symbolic. When stories don't add up, she cuts straight to verifiable truth. Case 3 closes with emotional gravity. Antoine D. has had every chance, every extension of mercy, yet the pattern repeats. His words are sincere, his regret real, but the judge is unmoved. After 3 failed probations and multiple revocations, she delivers what might be the hardest kind of justice, the kind that stops believing in promises. Her tone isn't cruel, it's weary, and that exhaustion mirrors society's own frustration with repeat cycles of rehabilitation gone wrong. Together, these cases reveal a justice system stretched between empathy and enforcement. Each defendant faces a crossroad, follow through or fall apart. The judges, meanwhile, walk a tightrope between compassion and control, proving that real justice isn't always about punishment. Sometimes, it's about finally saying enough. And if these moments hit you as hard as they did us, you already know what to do. If you found these cases as shocking as we did, hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Justice may be blind, but in this courtroom, it sure isn't silent.